With our story this morning regarding the college admissions scandal that many famous people got round up in recently. You'll remember this from about a year ago or so, where there were a bunch of famous people and famous parents who got caught up in this college admission standards scandal, where they basically bribed their way into colleges. Well, some of those parents have actually now had their convictions overturned by an appeals court. So, an interesting development. The First Circuit Court of Appeals, which deals with the northeast corner of the United States, Maine and such, has tossed convictions against Garnell Abdazela and all but one conviction of another parent, John Wilson. So, this particular Court of Appeals has taken a look and said, hey, as to these charges, as to these people, these are not valid convictions. So let's learn a little bit more about what happened and why the First Circuit reached this conclusion. Let's get started with this. The First Circuit Court of Appeals overturned all the fraud convictions Wednesday of two parents who were found guilty of paying bribes to get their kids into universities as part of that college admissions scandal that was in the news a year ago or so. The First Circuit Court of Appeals tossed all the convictions against Gamal Abdazela and all but one conviction of another parent, John Wilson. The Boston-based appeal court upheld Wilson's conviction on charge of falsifying a false tax return. So, lying to the government about the money and how much money they had, but not really directly related to the college admissions issue. The jury in Boston had found the pair guilty in 2021 of buying their kids' way into school as athletic recruits in a first case to go to trial in what was then called the Operation Varsity Blues investigation, which is a great name. The FBI sometimes comes up with these great names for these investigations, and they called it Operation Varsity Blues, which is kind of cool. So anyways, they were part of that investigation scandal that, of course, infected many schools all across the country, nationwide. The woman, Abdazelas, who is of Las Vegas, was accused of paying $300,000 to get her daughter into the University of Southern California as a basketball recruit, even though they didn't even make it onto the high school's team. So that is basically the deal, right? $300,000 bribe. You say that she's an athletic scholarship, but she has no athletic skill. So it's just a bribe to get you into school. So yeah. The authorities had charged Wilson, a former executive at Staples, having paid $220,000 to have his son designated at University of Southern California as a water polo sports scholarship, and in addition, $1 million to buy his twin daughter's way into Harvard and Stanford. So this affected a lot of different schools and a lot of different places with a lot of different things, but this was basically the scheme for a lot of them. Athletic scholarships was a major way that a lot of these scams worked, right? We give you money, you pretend they're an athletic scholar, they get into school. How much money are we spending? Hundreds of thousands to low millions of dollars each for the bribes. So, pretty serious stuff. The lawyers for the individuals who had been convicted argued their clients believed they were making legitimate donations, and an admissions consultant at the center of the scandal, William Singer, pitched his so-called side door scheme as a lawful one. So yeah, this gets into interesting domains of these issues, right? When is it lawful and when is it not lawful to do this kind of thing? And that's a good question because people do give donations to universities. And sometimes there is an expectation, sometimes unspoken, sometimes perhaps a little bit more spoken. But there is sometimes an expectation that, that new wing at the library comes with some sort of quid pro quo. And if that's spoken or not, but there might be an understanding. So the question becomes, okay, when is this legal? When is this not legal? When can you give money to a university for the admission scholarships or admission period? To what extent can the college take money for admission? So the idea that this might be legitimate is not, in the first instance, inherently absurd, because of course, some of this might be legitimate in a different form. Now, of course, the details are where often things get tricky, because very often the same act can be both legal and illegal, and a lot gets into a person's knowledge of things or their intent behind things. That's the mens rea element of the thing, right? So we don't require people to know the law, but we do require people to have a guilty mind, so that they have, in some sense, a knowledge or intent to do a nefarious thing. So a lot comes down to legal liability of a person's knowledge or intent of their own wrongdoing. And so if a person really doesn't think that they're doing anything wrong, they really believe that, and there's no reason to believe it objectively, then that might not be criminal. So that's the kind of thing we're talking about. The 3-judge panel of the First Circuit said the trial judge was wrong in instructing the jury that an admission slot constituted property of the university under mail and wire fraud law. So one of the issuing things is in fraud, right? Fraud is I lie to you to induce you to do a thing, right? That's fraud, right? I lie to induce. In the particular case of wire fraud, it requires the lie to induce to be in exchange for property, which often makes sense, right? I'm inducing you to give me money. That would be a typical fraud, right? I am lying to you about whatever in order to induce you to give me money under a false pretense. But of course, it doesn't have to be money. It could be some other kind of property, right? Fraud for land, fraud for a house, fraud for a car, fraud for some sort of property. So one of the questions legally is this admissions space at the university property? And the First Circuit says, no, it is not legally property in this sense. So you can sort of understand where that idea comes from, because it is somewhat distinct from the idea of a car or other sort of tangible or even intangible thing, because there's not necessarily a limit. A university can admit as many people as it wants. And it's not really property in that sense, because it can't be really, the slot can't really be given to another university. It can't be alienated from the university, right? If I own a car, I can give you my car. I no longer have the car, you have the car, right? So I have alienated that property from me. But a university can't really do that. One university can't give its admission slot to another university, so now they have an extra space. So the idea that that's property or not sort of makes sense. So that's probably one of the rationales behind it. The judge found the government also failed to prove the parents agreed to join the conspiracy, because conspiracy, of course, requires intent to join. A conspiracy by its nature is an agreement to do an illegal thing, and then an illegal thing occurs. But if you don't have an agreement to do an illegal thing, you don't have a conspiracy. You have to have agreement. And if they didn't realize they were agreeing to an illegal thing, it's not conspiracy. You have to have some idea that what you're doing is illegal. So yeah, that makes sense too. The court noted that the government was allowed to introduce significant amounts of powerful evidence related to other parents' wrongdoing in which these defendants played in no part, creating an unacceptable risk that the jury convicted based on others' conduct. So yeah, that's obviously a problem, right? If you're part of a conspiracy, then you can introduce evidence of other people in the conspiracy, because you're part of a conspiracy and you're along for the ride. Conspiracy doesn't necessarily require that you know what other people in the conspiracy are doing, or even that there are other members of the conspiracy. This is one of the downsides of joining conspiracies, people. You don't want to join conspiracies, because if I join in a criminal conspiracy with you, and then you independently, and not to my knowledge, extend the conspiracy to another person, guess what? Suddenly now I'm in a conspiracy with that other person. I don't even know they exist. But now they're part of the conspiracy because you, my confederate, brought them into the conspiracy. As my partner in the conspiracy, I am responsible for the things that other partners in the conspiracy do, including adding other partners. And I don't necessarily know that they exist, or even know what they are doing, or their criminal actions. But if I'm part of the conspiracy, well, sucks to be me. So don't join conspiracies and you won't run into this problem. But if they are not part of the conspiracy at all, if they're not part of this conspiracy, and we're bringing in evidence of other people's wrongdoings, well, now suddenly that's a real problem. Because Jack broke the law doesn't mean I broke the law. If we're not part of a common device, a common plan, a common agreement, if I'm not an accessory, I'm not a conspirator, it's like, okay, well, we both independently broke the law. Maybe. What does one thing have to do with the other? Nothing. So to the extent that you're doing that, that's a real problem. The ruling, of course, is a blow for prosecutors who netted 50 convictions in the scandal, presumably because, of course, this decision would potentially impact other decisions in other circuits with respect to other people, depending on the specificity of what exactly happened. So depending on the details, of course, and depending on how other circuits look at it, of course. But, one court of appeals has looked at this and said, okay, not so much for the wire fraud. So, of course, everyone else is saying, hey, wait a second, maybe not so much for the wire fraud, me too. Maybe I'm also not guilty of the wire fraud or other things. So, of course, this has some potential ripple-on effects depending on the details. This, of course, went from various colleges, including Yale, Stanford, Georgetown, University of California, Los Angeles, and many other schools, some of which are not necessarily elite schools, incidentally. So the bribes were a little bit strange because they weren't necessarily that selective. Some of these schools, obviously, extremely selective. Other schools, part of the scandal, not so much, which made you wonder why they were doing it, but whatever. The attorney for the United States government says they're reviewing the opinion and next steps. Your next steps include asking the First Circuit for an en banc or asking the U.S. Supreme Court for review, either of which is difficult. Also trying to prevent spill-on effects into other circuits, So, yeah, but they're looking into it. The attorneys for the people who had previously been convicted emailed a statement saying that their clients have maintained absolute innocence and they're enormously grateful. I bet they are. We're pleased to have represented our clients and look forward to putting this behind them. Yeah, okay, so, good for you guys, I guess. Thus, that brings us to the end of the discussion for the moment of this latest update in the college admission scandal from a couple years ago. There were a bunch of people who got caught up in the scandal with 50 convictions for various parents who bribed their way into colleges, often by convincing the college one way or another to create an athletic scholarship for their kid who had absolutely no athletic skill of any kind. So just money for admission. And this could have been fraud, but maybe not, because, well, under the relevant statute, an admission space may not be property, which makes logical sense if you think about it. Doesn't really have the sort of things that property do. You can't really alienate it. You can't really destroy it. It's not really limited. So yeah, it's not really property in a conventional sense. And also that they weren't part of the conspiracy because, well, they didn't necessarily know that they were doing something illegal or have any clue that what they were doing was illegal. They didn't have the necessary mental state of knowledge or intent, for example, to join in a conspiracy. So if what you really think you're doing is just, doing what is legal, then that goes a long way to your mental state as a matter of fact rather than a matter of law. So yeah, they look at this and like, okay, well, those things. And obviously, this will impact cases beyond these people because suddenly 50 other convictions have suddenly, maybe those other convictions also have similar problems. But of course, maybe not, because it would depend, of course, on the specific details. But you can bet your bet that a lot of other lawyers are taking a second look at those convictions and looking at the details right about now. But that, for the moment, brings us to the end of discussion of this case.